Well, good morning or good afternoon to all of you joining us today, depending on where you are joining us from. My name is Phil Lee. I am the Managing Director here at Digifile, and we are delighted to have you joining us today. We are going to be discussing 2023's Privacy Bonanza key trends and takeaways. And Michael, if you can just advance forward a slide, please. This presentation is brought to you today in celebration of Data Privacy Day. For those of you who are not already aware, yesterday, the 28th of January, was Data Privacy Day, not a working day, so unfortunately we couldn't give this presentation to you then. However, we are very glad to be celebrating it, and because we are all in party mood, Michael, if I can go forward one. Here we all are in our party hats celebrating Data Privacy Day like true data privacy nerds. So we are glad to have you here. Now, if we just move forward one slide, why was 2023 a bumper year for data protection? I can go forward a slide. Well, let's take a look at what happened in 2023. If you look back over the period of the year, we had 28 Court of Justice decisions, Court of Justice of the European Union decisions, 28 decisions. We had 12 European Data Protection Board guidance papers, 39 one-stop shop decisions. That's those decisions that are taken by the DPAs across all of Europe. We had 6 fines that were issued in excess of 10 million euros, one at a record-breaking 1.2 billion euros. That was for Meta for its data transfers to the US, but the largest fine ever issued. We also had the adoption of the EU-US data privacy framework, and all of that before we started thinking about things like the AI Act or the Data Governance Act, the Data Act, the Digital Markets Act, the Digital Services Act. There was just so much going on. And Michael, if we can just go forward one slide, please. If you graph that all out, if you look at the Court of Justice decisions that took place between 1995 and 2024, 1995 chosen because that was the date that the original Data Protection Directive was adopted. If you look over that period, you can just see how many more decisions there were at a Court of Justice level in 2023 than any other year. 2022 also kind of a bumpy year, but 2023 also really, really big. Now, if we go forward one more slide, just to put that in perspective, that means that almost 50% of the data protection decisions that were taken between 1995 and today, almost 42.9% of them were taken after 2023. That just makes you realize of how big the past 12 months have been for data protection. So what have we been doing here at Digifile? Well, if you're anything like me, that's an awful lot of information to try and take in. And so we here, the Digifile elves, we have been sort of plowing through all of this stuff and trying to work out what are the key trends and takeaways to take away from all of this. And I realize in doing all of this, I've been very remiss. I should mention that speaking with me today, I'm joined by Michael Brown, who's a side-loading lawyer, a senior consultant here at Digifile, and we have Marco, who is a terabyte lawyer as a senior associate here at Digifile. I got so excited looking at our party hats, I completely forgot to mention that, so apologies to you both. But these are the key trends that we have been identifying from the past year, looking at all of these decisions. And we think they broadly fall across 6 areas. We're talking about adtech and profiling. We are looking at data subject rights. We are looking at liability and compensation. And those are the things we're going to be focusing on today, because we think that's where the bulk of the decisions have been happening, and that's where some really interesting stuff has been said. Unfortunately, we won't have time today to look at some of the other trends around anonymization, protection of children, data transfers. But hey, if you like this session enough, who knows, maybe we will be back. So you will see at the bottom of your, yeah, there you go. You got a little thumb at the bottom there. You should see at the bottom of your session panels, there's the option to interact with the session. Please, we're incredibly vain. We do love the feedback. Go for it as we're going through this. Okay, Michael, if you can move forward, please. So I have got the job of speaking to you about the first part of this presentation, which is looking at the adtech and profiling implications of the past 12 months. If you can move forward to the first case, Michael. So to begin with, we're going to start with a decision that happened right at the beginning of the year, which was the Irish DPC's investigation into Meta, and specifically Meta's reliance on contractual necessity to serve targeted ads on its platform. Now, what was the background to this? The background was that when the GDPR came into effect, Meta updated its terms of service. And being a platform that is funded by the advertising that it serves, it changed its terms of service to say that it relied on contractual necessity to target ads. Why did it do that? Because under the GDPR, you have to tell people what your legal basis for processing is. And it seemed common sense in many ways. If you are providing a service funded by ads, then it's contractually necessary to process data to target those ads to you. That was the thinking. However, everybody's favorite privacy campaigners, none of your business, they raised a complaint about this to the Irish Data Protection Commission, and they said that in effect, this amounted to forced consent because people who use Meta had no choice but to accept these terms in order to use Facebook and Instagram. Now, it's kind of an interesting decision because there was a bit of an argy-bargy between the Data Protection Commission and the European Data Protection Board. Initially, the Data Protection Commission came down with a decision that was a little bit more favorable, perhaps, for Meta, but ultimately there was a dispute at the European Data Protection Board level, that it went through the dispute resolution procedure, and what ultimately emerged was a decision where the DPC ended up having to impose fines of 390 million euros in aggregate across Facebook and Instagram. And those fines were imposed for across three different areas, really. Two of them being related: fairness and transparency. What the DPC said was that that Meta wasn't sufficiently transparent and therefore not sufficiently fair about the data it was collecting, what it was using that data for, the purposes it was using it for, and the legal bases relied upon. So you may see in a lot of privacy notices nowadays, you'll see people will include things like a table that has one column for data, one for purposes, and one for legal basis. That's what authorities expect to see. But on this point around contractual necessity, it was very interesting because the DPC had originally said that it felt that Meta could rely on contractual necessity to collect and use people's data for targeted advertising. And this is where the European Data Protection Board ultimately disagreed with it. What they said was that in order to rely on contractual necessity, the processing actually has to be necessary for the performance of the core purpose of the contract. And in the EDPB's view, the core purpose of social networking is communication. It is not advertising. And so you couldn't say that targeted advertising was necessary for that. They also made a couple of other interesting points. They said that under the GDPR, individuals always have the right to opt out of direct marketing. And if you can opt out of direct marketing, and that includes targeted advertising, if you can opt out of it, then clearly it can't be necessary to perform a contract. And the other thing they really focused on was they said there are other less intrusive options available to Meta. They felt that it was open to Meta to rely on something like contextual advertising or maybe even demographic advertising, not targeted advertising based on collecting people's behavior. And so they said that again pointed to the fact that you couldn't say targeted behavioral ads were contractually necessary. Slide forward, please, Michael. So what are the practical consequences before that? Well, before this decision, I think most people would have said there were three potential bases for engaging in targeted advertising: consent, reliance on contractual necessity, and legitimate interest. Post this decision, it seemed to be that there were only two possible grounds: consent and legitimate interest. And often you will hear advertisers say that they worry about relying on consent because if you ask people to opt into targeted ads, very few people do that. That has an impact on advertising revenue. So Meta looked at its options and decided to pivot to legitimate interest as its basis for advertising. But see the next case. Before we get onto that, as I mentioned, other practical takeaway from this: if you're preparing your privacy notices, make sure that you do clearly link data to purposes to lawful basis. It's not enough nowadays just to say we collect this data, we do these purposes, and we rely on these legal bases. You need to join the dots together so you can see what data for what purpose, for what legal basis. Next slide, please. So that brings us on to the next case, which was I'm not even going to try and pronounce the German, but the English translation is roughly the Federal Cartel Office, Meta and the Federal Cartel Office. Now, the last one was a regulatory decision. This was a Court of Justice decision of the EU. And what happened here, same kind of thing. Users sign up to Facebook, they have to accept Facebook's terms. And as part of those terms, Facebook made clear that it collected data outside of the main Facebook platform. We call this off Facebook data. And it uses that for a variety of purposes, including advertising. That off Facebook data could be data from other Meta services like Instagram. It could also be from third-party websites where Facebook's advertising tools are integrated. And what happened here was the German competition authorities were looking into it. And they basically said, well, in order to investigate whether Meta is making abuse of a dominant position, we need to look at whether they are being compliant with data protection law. And they, in particular, wanted to look at whether this kind of requirement that users have to accept these terms and accept this collection was compliant with data protection, which raised a really interesting question because it basically brought about a whole issue of, can a competition authority assess an organization's compliance with data protection? Again, it went all the way up to the CJEU, and the court ruled that yes, competition authorities can investigate data protection compliance if it's relevant to a competition investigation, subject to a duty of, quote unquote, sincere cooperation with data protection authorities. In other words, what the competition authority says has to be consistent with what the data protection authorities say. So you need to make sure that any ruling you make is consistent with previous rulings of DPAs, and if you're in any doubt, you need to consult with them. Now, it also made a couple of other interesting points. It said that if you're using cookies to gather data from websites that are related to special categories of information, so things like race, religion, sexuality, all of that kind of stuff, if you're collecting cookie data automatically from those sites, that cookie data is going to qualify as special category data. Consequence of that under the GDPR is that you would normally need consent unless you could show that a non-consent based ground applied, like the individual had chosen to make that data manifestly made public, which was one of the arguments that was put forward. And the court said, no, just because somebody visits a website that is related to a sensitive topic, that does not mean they have chosen to manifestly make that data public to anybody who's got tools embedded in that website. You have to have an explicit choice from the individual to choose to share that sensitive data with you. We move forward a slide, please, Michael. Now, this is where it gets really interesting because and there's so much to take away from this. I'm going to do my best to condense it down. But basically, what the court did was to say, well, if you're an online social network and you're collecting data from other third-party sites and services, what are the legal bases that you can rely on? And they went through each of the different legal bases. Now, this wasn't just for advertising. This was for lots of things. So it was for security, improving products and services, sharing with law enforcement, all the different reasons why an organization like Meta might need to use data. And what they did, we'll focus on consent, contraction, necessity, and legitimate interest. What they did was they said, yes, you can ask people for consent to collect their data on third-party sites and services, but you have to prove that consent is freely given. And particularly when you're a big organization like Meta, there's a real burden on you to demonstrate that there was a free choice whether or not the individual chose to consent. So consent possible. For contractual necessity, they said, well, yes, you could rely on contractual necessity to collect data on third-party sites, but only if it is objectively indispensable to the contracted services you're providing. And so I was trying to think of a good example here. And I was thinking, like you get these kind of services where you browse around the internet and you maybe clip news articles that you want to read later. Now, you contract to receive those services. Those services literally cannot function unless they save the articles that you've been reading on third-party sites. You can see they might argue it's contractually necessary to collect data that you're interacting with on third-party sites in order to provide that service with you. It's objectively indispensable in that context. But the court said here that they did not think that the collection of data on third-party sites for personalized advertising was justifiable under contractual necessity. And they also said kind of a general purpose of collecting data for seamless use of group services was not also justifiable under contractual necessity. Which then takes us to legitimate interest. Because if you remember, under the previous decision, we said that Meta pivoted from contractual necessity to legitimate interest. And the court said here, again, collecting data from third-party sites is in principle possible under legitimate interest, subject to fulfilling the balancing test, but not for personalized advertising. And interesting, what they seemed to really focus on here was the scale of Meta's data collection. They said it's just beyond what anybody would reasonably expect when they sign up for Meta services. And then they also had a couple of other interesting points where they said, nor can you justify sharing data with law enforcement on legitimate interest, and it's doubtful whether widespread collection of data on third-party sites for your own product improvement is justifiable in legitimate interest. Now, how many companies do that? An awful lot. So it's a very significant ruling. We move forward a slide, please. So what are the practical consequences? Well, this was a decision about online social networks. That's the first thing to remember. And when you read the decision, all of the rulings are characterized in that sense, but its impacts go much further beyond that. Firstly, what you can take away from it is avoid placing cookies on sensitive websites, because if you do, you're going to be collecting sensitive personal data, and that's very restricted under the GDPR. Next off, this ruling seems to suggest that it is going to be difficult, if not impossible, to rely on contractual necessity and legitimate interest to track users on third-party websites for advertising purposes. It seems that consent is likely to be the only way forward for targeted advertising. And it also seems to be saying that reliance on legitimate interest for product improvement, including through things like machine learning, and again, think about how many companies are collecting data across the web currently for machine learning, is not justifiable under legitimate interest. So again, another very significant ruling. We move forward a slide, Michael. And to kind of reinforce this point, you'll see that the EDPB in November last year basically issued a ban, a European-wide ban on behavioral advertising based on contracts and legitimate interests. With the result, Michael, move forward. That Meta has moved to what we now call the pay or okay model, which is simply that you can either agree to advertising and use Facebook for free, or you can pay for it and use it without advertising. And this itself, you would think, this itself has proven to be controversial because the civil advocacy side of the fence has said that, well, this amounts to basically saying only rich people can have privacy because nobody's going to want to pay that amount of money to use online services. That is now going to be the subject of regulatory investigation. We will expect an opinion on it in due course. So it is very much an evolving space. We can move forward, Michael. So next up, we have another adtech decision. This one, a data protection authority decision. This was the CNIL investigating Criteo, an online adtech company. What happened here was that you had Criteo, which at the time, probably more now, but was collecting about 35 billion online events per day globally. If you're wondering what an event is, it means a user's action online, viewing an advert, interacting with an advert or a website. It was collecting 35 billion events online and had apparently identifiers relating to 370 million users throughout the EU or their devices. And so complaints were made against Criteo by Privacy International and None of Your Business. And the CNIL, as the lead authority for Criteo, it being a French company, investigated. What was decided? Well, they did decide that Criteo was in breach of the GDPR, and they imposed a 40 million euro fine, which amounted to about 2% of Criteo's turnover. Now, actually down from 60 million that was originally proposed. What did they find wrong? Well, they said that Criteo had failed to ensure consent. What Criteo said was that because they were just a vendor, they weren't the websites themselves. They said they had a contractual term on their websites. Their websites were responsible for getting consent for the cookies that they placed, and that so Criteo couldn't be held responsible if that consent wasn't obtained. The CNIL said, no, you have an equal responsibility to ensure that a valid consent has been obtained. And of about half of the websites that the CNIL inspected, they found that there was no consent and no ability for Criteo even to audit the company to see whether a consent had been obtained. They also said that Criteo had been insufficiently transparent. They said that when you looked at Criteo's privacy policy, it seemed to rely on a mixture of consent and legitimate interest for behavioral advertising. And the CNIL said that's just unclear to users. Consent is what's required under the privacy directive. So they had issues with them around that. And again, back to machine learning, they said that Criteo hadn't called out machine learning as a separate purpose in its privacy notice. They sort of saw machine learning as part of overall providing its products and services. It was part of its overall product improvement. And the CNIL said, no, you've got to call that out separately in your privacy notice. There was also some issues around the fact that Criteo had received a data subject access request. They hadn't provided all the data they had. There was a couple of tables of data they hadn't supplied. And when somebody withdrew their consent to advertising, Criteo stopped advertising to them, but it didn't delete all the data it had previously collected about them. And the CNIL said that wasn't good enough. And lastly, what the CNIL said, if you were trying to say that the websites are jointly responsible with you for providing transparency, collecting consent, then you need to have a fully formed joint controller agreement with them. And if we just move forward a slide, Michael. The interesting thing about this was, as this investigation was ongoing, Criteo was remedying these things through its various sort of courses of correspondence with the CNIL. And so by the end of it, the CNIL sort of seemed to say, we acknowledge that Criteo has basically fixed all the things we found. So the penalties were like, if you like, for Criteo's historic non-compliance. So what a lot of ad tech companies have been doing since then is having a look at Criteo's terms online and their privacy notes, say, okay, how do we need to amend our terms to get in compliance? So it's quite a useful roadmap in that sense. And if you take a look at that and you take a look at the decision, what you take away from it is that, firstly, if you're an ad tech company, you're responsible for getting consent, and you need to make sure that if you're relying on your website partners to get consent, you have the ability to verify that, at least to require proof of consent upon request. You also have to reserve yourself the right to audit compliance and to actually audit compliance, not just say you'll do it and then never do it, not just have the right and never do it, but actually to do it. And if you find that any of your partners are non-compliant, you do need to terminate. Again, one of the things that Keneal picked up on was that Criteo had non-compliant partners that it had never terminated. In your privacy notice, you need to make clear that you're using consent for ad targeting and not have a kind of confusing mix of consent and legitimate interests. And you do need to disclose product improvement or machine learning as a separate purpose. For data subject rights, very simple. Make sure you disclose all the data that you have. If you're an ad tech company, that includes your bid data and any deterministic matching data. And if somebody opts out, it's not just a question of stopping serving them ads. You also need to delete the data you have about them. And then for your joint controller terms in your agreement, you need to make sure that you agree who's providing transparency to the user, who's responsible for fulfilling their rights, both of which are required under Article 26. But also you need to include other things like, if there's a data breach, who's responsible for giving breach notification to the regulators and the individuals? Who is responsible for conducting a DPIA? Those things also need to be covered in your joint controller agreement. We can move forward a slide, please, Michael. This brings me on to my final case, which is the Schufa case. That happened in December last year. What happened? Well, Schufa is a technology vendor, and a credit scoring provider, really. And what it does is to provide a probability score on consumers' credit worthiness. So if you're a bank or you're a website that's looking to contract with a consumer, Schufa can provide you with a score that tells you how creditworthy that individual is. Now, what happened in this case? A data subject was denied a loan on the basis of Schufa's score. The bank decided to refuse their data subject a loan based on whatever score Schufa had returned about them. They made an access request to Schufa, and Schufa provided them with some information, but they didn't provide them with a lot of information about how they'd reached that score, and the individual felt that that was inaccurate. Ultimately went all the way up to the Court of Justice of the EU, and what the court said was that, the key decision to be made here was this probability score, was it an automated decision? And why does that matter? Well, it matters because under the GDPR, if you engage in automated decisions under Article 22, you are required to provide meaningful information about the logic behind your decision. In other words, how you're arriving at that decision. And Schufa said it didn't make automated decisions. It just provided the score to the website or the bank or whoever, and they took the decision whether or not to engage with the consumer. Now, what the court said was that actually, if you adopted that interpretation, it leaves a hole in the law, because the bank or the website or whoever, they don't know how that score was reached, so they can't provide meaningful information to the individual. And if you say that Schufa wasn't taking decisions, then they have no obligation to provide that meaningful information to the individual. So they said to make sure individuals have rights to this information because it has a significant effect on them. A probability score does amount to an automated decision if a third party, quote unquote, draws strongly on that score and uses it to establish, implement, or terminate a contractual relationship. Go forward a slide, please, Michael. So what are the practical consequences of that? Well, if you are engaged in that kind of probability scoring and it has a legal or similarly significant effect, in principle, that's prohibited under the GDPR unless you can show one of a small number of conditions that either the scoring is contractually necessary, that it is authorized by EU or member state law, or that you have explicit consent from the individual concerned. And in addition, you've got these transparency requirements to provide meaningful information about how you arrive at that scoring. And you have contestability requirements, which means that individuals can challenge the score and have a human look at it. And that has obviously impacts to things like banking and insurance and e-commerce, but it also impacts other sectors as well. Think about predictive diagnostics with healthcare, or maybe employment. You have a tool that reviews people's resumes and issues a score about how employable they are for you. Those kinds of things now are going to be caught by this decision and considered to be automated decisions. As for ad tech itself, well, there is often scoring in ad tech. It is often used to assign people to behavioral categories. But arguably, ad tech doesn't have a significant effect in the same way that some of these other things do, and so maybe isn't caught by Article 22. So that brings me to the end of my cases. I can see some questions coming in. I'll deal with those at the end. But for now, I'm going to hand over to Michael, who's going to talk to you about data subject rights.
Thanks, Phil, and hi, everyone. So today, as Phil mentioned, I'll be walking you through for CJEU judgments in the field of data subject rights, and specifically data subject access requests, which are also known as DSARs. So as general context, the underlying right of an individual to access or obtain information about their data from controllers really is a cornerstone of European data protection law. And also my experience, and I'm sure I expect this is shared by many of you in today's webinar, is that responding to DSARs can be very time and resource intensive, from collating the data initially, to reviewing it, to assessing what's in scope, to then performing the legal analysis as to ascertaining what's disclosable, what's not disclosable, etc. So I'll try, therefore, today to really explain the case facts, the decisions, and crucially, the practical implications as clearly and helpfully as possible. So the first case is RW versus Österreichische Post, which concerned a DSAR from an individual consumer to the main postal and logistics provider in Austria. The dispute focused on Article 15.1c, which sets out requirements regarding the data subject having access to the recipients or categories of recipients to whom their data has been or will be disclosed by the controller. So in this case, the consumer was dissatisfied with the response to his request, and specifically with being provided with just the categories of recipients. So, for example, marketing agencies, for example, IT service providers, rather than the actual names slash identities of the recipients. So marketing agency X, Y, Z, IT service provider X, Y, Z. So what was decided? Well, the court held that Österreichische Post was indeed required to provide the actual identities and not just the categories if requested by the data subject. And I'll come on to that if when I talk about practical consequences in the next slide. The court also decided that the requirement does not apply if the DSAR is manifestly unfounded. So, for example, if it's malicious intent, designed to cause disruption, or excessive, so a repetitive request, for example. So the usual DSAR carve-outs were made reference to by the court. Also, the requirement is inapplicable if it's impossible to disclose the IDs. There wasn't a huge amount of commentary in the judgment as to what would constitute being impossible to disclose. Hopefully there might be some guidance from European data protection authorities on this point. But there was a brief mention of recipients who might receive the data in the future. So clearly controllers might not be in a position to have the crystal ball and be able to forecast all the different recipients of data kind of going forward. So turning to the practical consequences for controllers who receive DSARs following this judgment. Three key ones. First, there's likely to be a need to update DSAR internal policies or template responses if, as an organization, you've potentially been operating on the basis of simply providing categories of recipients as a blanket response. So in these updates, consideration might need to be given to how you respond to a general request. So the very common request along the lines of, please, could you provide all the data you process about me? So organizations might want to assess their approach to whether to provide the actual identities of the recipients in that initial response, or seek to clarify the scope of the request from the requester, see if they actually really do want the IDs of the third-party recipients, or whether they're potentially happy with kind of categories. But clearly, also organizations should review the request wording carefully, and if asked for the IDs, the court made clear that these should be provided. Secondly, the judgment implicitly reaffirms the importance of organizations having good granular data maps to be able to provide the actual IDs of the recipients. So just being able to kind of pinpoint exactly where the data is going to the extent possible to be able to provide as precise as possible information. And then thirdly and briefly, the judgment removes any potential ambiguity around the scope of kind of timings of recipients who've received the data. So controllers do need to provide recipients who've received the data in the past, currently, and then if possible in the future. So zooming out a little, the judgment seems to have as its kind of main driver individuals really understanding where their data is flowing to, or having the ability to understand where their data is flowing to, so that they can then access potential kind of control of it that was referred to in the judgment. So then upon receipt of the IDs of the third parties, maybe being able to submit a deletion request to that third party. So just mapping out the kind of flows of the data to be able to potentially exercise rights. And then second point of kind of zooming out a little, obviously this could be practically quite an onerous requirement on controllers who rely upon many third parties to provide their services. So in the ad tech ecosystem, for example, so that should be kind of taken into account as part of your kind of compliance programs. And it also seems to indicate from the court just a bit of a push towards responses to DSARs being a bit more nuanced and a bit more targeted. So moving on to case two, this is FF against the Austrian Data Protection Authority with CRIF GmbH as an intervening party. So this concerned a DSAR from an individual consumer to a German consulting and credit risk company called CRIF, which was escalated to the Austrian Data Protection Authority. The dispute focused on Article 15.3 of the EU GDPR, which requires the controller to provide a copy of the personal data undergoing processing in response to a DSAR. So in this case, CRIF simply provided the requester with a summary. From recollection, it was a list of the data processed. The requester thought CRIF should have sent him a copy of all the documents containing his personal data to comply with the law. So kind of quite divergent approaches and understanding of what constituted compliance. So what was decided? First, the court held that the term copy, albeit undefined under GDPR, would refer to the personal data and not to the document containing the personal data. Second, it was decided that CRIF must provide a faithful and intelligible reproduction of the personal data to the requester rather than just a summary description. And then just looking at some of the practical consequences of this judgment. So I've set out three. They overlap to a certain extent, but kind of hinge on providing the data and providing kind of context around the data. So first practical consequence is that the judgment implicitly reminds organizations when conducting those initial searches and reviews of potentially what's in scope to focus really on the data versus the base documents which might contain the data. Secondly, and crucially, there's the need to provide context to the data disclosed. So a spreadsheet with a standalone IP address or some other unique identifier without any description is unlikely to be compliant if disclosed solely in that form. There's the need for accompanying an accompanying description or providing the base document but redacting proportionately. So there's enough information remaining that the requester actually understands the data within its context. Third, and again, this is kind of linked to points 1 and 2, really, the judgment reaffirms the kind of expectation around targeted and tailored disclosures in response to a DSAR, rather than what's sometimes known as a kind of document or data dump. Actually, this might, there's one interpretation that this might help to reduce a company's risk profile, whether it's to do with security breaches, so disclosing third-party data by accident in a document, or infringing upon third-party individuals' rights whose data shouldn't be disclosed. So this targeting tailored approach may be helping with compliance. So moving on to case 3, this is JM versus the Finnish DPA with Pankey as an intervening party. This case concerned a DSAR from an individual who was, quite interestingly, both an employee and a customer of a Finnish bank called Pankey. The individual complained to the Finnish DPA about the response from Pankey to his DSAR request. And the dispute focused on Article 15.1 of the GDPR, which sets out the information to which an individual is entitled, subject to some carve-outs, pursuant to a DSAR. The judgment also touched upon Article 4.1, definition of personal data. So in this case, the data subject was under the impression that some bank staff members had accessed his own customer data, and so requested 3 things. 1, the identities of the staff members, 2, the dates of access, and 3, the purposes for which his data was accessed by the staff members. The bank provided some general information about the access, which had occurred, but not the staff member IDs. So in terms of the decision, the court held a number of different points. So firstly, although the requester's data in scope of the request went back to 2013, so pre-EU GDPR, obviously, it was still a valid request because it was submitted in late May 2018, so post-EU GDPR entry into force. The court also held that the requester was indeed entitled to the dates and purposes of processing activities. And then notably, the court held that the requester was not entitled to the names of individuals performing the processing activities unless they were essential or are essential to exercise his or her EU GDPR rights, and their rights and freedoms have been taken into account in that kind of consideration. Again, there's not a huge amount of commentary, if any, in the judgment on what constitutes something being essential, and that might be fleshed out in some guidance from the authorities. And then finally, the court held that the bank's status as a regulated entity and the requester's status as an ex-employee was irrelevant to the access rights scope. So turning to practical consequences, first provides kind of further reinforcement that the courts view the definition of personal data very widely, so dates and processing activities connected to an individual well-being scope. Second, there's a retrospective application for DSARs in terms of processing which might occur pre entry into force of the GDPR, so maybe a procedural point to pick out in your internal DSAR policies if that's not quite specified. Third, maybe the naughtiest practical consequence, there's kind of consideration as to how to treat third-party individuals' data. So likely need to redact their information. Of course, and this is a longer discussion, there's some grounds in which you can seek their consent to disclose the data. Query whether that might be essential in view of the eyes of the court. But yeah, a real kind of focus on being careful around the roles of the third-party individuals who are kind of connected in the data which is in scope. And then lastly, DSARs are obviously often used to gather information and a tool in employment-related disputes. So if a DSAR comes in from a current or ex-employee, consideration might need to be given by organisations that could be a precursor to litigation, so particularly sensitive and sometimes time-consuming. And then moving on to my final case, and I'll go through this one relatively quickly in order to hand over to Marco in good time. This is a DSAR from a patient to a dentist. The dispute relates to Article 12.5, which sets out the position around charging for responses to a DSAR. It also concerns general Article 15 provisions, and then lastly, Article 23, which sets out the restrictions on which EU or member state law can impose on data subject rights. In this case, the facts were quite straightforward. Patient submitted a DSAR to the dentist for his medical records. She pushed back, responding that pursuant to national German law, she could only provide the records if he agreed to cover the costs. So the court decided that the controller, so the dentist, is actually required to provide the first copy of personal data free of charge. It also set out that national legislation cannot be adopted which contravenes this requirement, so showing the supremacy of CJEU decision making. And then lastly, confirmed that the controller must provide the data subject with a faithful and intelligible reproduction of medical records requested, so same language as used in the previous case which I referred to. Practical implications, twofold. First, straightforward, controllers can't charge for that first copy of data. Query whether that might result in controllers trying to understand the scope of the request a bit more carefully. So does, in this instance, the patient want a specific medical record or a date range of records, or they want the whole batch, just so they can understand kind of cost considerations. And then second kind of practical consequence, and this is part of my overarching sum up, it just really does demonstrate the importance of data subject rights as part of the European data protection law framework, considered even against kind of national medical legislation. So an interesting case, an interesting batch of cases, pro data subject, more nuance towards responses, and lots to kind of think through. So with that, I shall hand over to Marco.
Thank you so much, Michael. And I promise everyone, I'll do a summary of my summary to make sure we have enough time at the end to answer your questions. So, Michael, if we can move to the next slide, the first case, we see that 2023 has been a huge year for data protection, but also for the Austrian Post Office that again appeared in front of the European Court of Justice in this case in relation to a particular processing activity. So they collected and inferred the affinity to specific political parties of Austrian individuals, and they were doing so without their consent. All this was happening in the context of a larger business operation of the post office as address broker, where they would package and sell the third parties target group address for these third parties to carry out targeted advertising. One of the Austrian data subjects, the applicant in this case, claimed that the infringement of GDPR, the processing of special category data without consent, led to non-material damages in the form of a loss of confidence and a feeling of exposure, and therefore claimed a compensation of non-material damages under Article 82 for the amount of 1,000 euros. The European Court of Justice decided that claiming an infringement per se is not sufficient to give rise to a right to compensation of non-material damages. Under Article 82, the European Court of Justice tells the subject that they have a specific burden of proof, that they have to prove three cumulative conditions. First, the infringement.
that an infringement occurred. Second, a damage that has been suffered, i.e. a loss that should be reintegrated through the non-material damages. And third, a causal link between the infringement and the damage. The European Court of Justice also spends a few words on the amount of the compensation of non-material damages and says that it is not necessary for non-material damages to be compensated to reach a certain degree of seriousness. Whatever is the damage suffered by an individual, that should be compensated, because the purpose of GDPR is to integrate a full restoration of the position of an individual, whatever is the amount of the damage suffered, because the goal of the law is a full and an effective compensation. So what are the practical consequences of this decision? Well, good and bad news. First of all, there is a very specific burden of proof for data subjects. They have to prove 3 elements, which might not always be easy to prove. Again, infringement occurred, damage suffered, causal link between the 2. And when it comes to the assessment of the amount to compensate for such non-material damages, we have good news. There is no space for punitive damages under GDPR for the principle of reintegration of the position of the data subject. But also there is no de minimis rule. Any damage should be compensated. And the problem is that GDPR does not give very specific rules or guidelines on how to calculate such damage to be compensated, because that is the job of the law of the member states, which then could lead to the problem of foro shopping, where people or entities behind class actions may decide where is more profitable to initiate that kind of claims. Moving on to the second case, we are again in a situation where we have an individual claiming compensation of non-material damages. In this case, again, we have a claimed breach of the GDPR, but in reality, the reality of the fact is that the claim follows a data breach. So we are in Bulgaria. We have the National Revenue Agency, which suffered in 2019 a cyber attack where malicious actors gained access to the personal data of over 6 million individuals, and followed and then published such data on the internet. The applicant in this case claimed that there was an infringement of GDPR given by a breach that would be integrated by the failure to implement those appropriate security measures required under Article 32 of GDPR by a controller, which led to non-material damages consisting in the fear of the applicant, of the data subject, that being her data published on the internet, that could have led in the future to blackmail, assault, or even kidnapping. The European Court of Justice, facing this situation, first of all, solved the problem of whether or not a cyber attack, a data breach, is per se sufficient to integrate an infringement of GDPR in the form of failure to adopt those appropriate technical and organizational measures required by both Article 24 GDPR and Article 32 GDPR. And the answer is negative. The European Court of Justice says clearly that GDPR does not have the goal to eliminate completely any and all the risks relating to data breaches. Again, being a risk-based legislation, what Article 24 says, what Article 32 says, is that the obligation of organizations, either controllers and processors, is to implement appropriate technical measures to comply with the different requirements. And the appropriateness must be based on the material circumstances of the processing, given the nature of the processing, the scope, the data at stake, but also taking into consideration the likelihood and severity of the risks for the data subject. So the duty of a controller, in this case, the Bulgarian Revenue Agency, was to try to avoid a data breach as far as possible. And who has to bear the burden to prove that such appropriate technical organizational measures were put in place? That is always a burden resting on the controllers or processors by virtue of Article 5 GDPR that clearly says that organizations have a duty to do basically two things when it comes to security. Action number one, identify the risk, triage the risk, understand the risks in terms of consequences for data subjects, in particular when it comes to likelihood of a risk occurring and severity of the risk for data subjects. And second action is to, assess the appropriate measures to mitigate such risk. Again, speaking about the amount of non-material damages to be refunded, the European Court of Justice says that data subjects have a specific burden of proof that we have analyzed before, and that fear per se is capable of being a refundable non-material damage. What was lacking in these particular circumstances was the assessment by the court of the member state as to whether or not that claim was well funded or not. So again, the burden of proof, the duty of evidence, your damage was not completely fulfilled by the data subject in this particular case. So what are the consequences of this decision? Well, the key word that comes to mind is accountability. If an organization wants to disclaim any liability in relation to a data breach, you must be in a position to prove you have done your homework. You have identified the risks, you have assessed your risks, and you have assessed the security measures you're putting in place are the best you can for that particular circumstance. And again, something else to bear in mind is that fear, it is a refundable non-material damage, although always subject to burden of proof by the data subject itself. Moving on to the next case, we are moving into liability regime of data controllers. So we're moving from Article 82 GDPR to Article 83 GDPR. This is a procurement story. We are under COVID time. We have a public sector body in Lithuania which is engaging an IT service provider to create a COVID tracing app. This engagement occurs in a very particular way. There is no contract between the parties. There is a number of exchanges occurred via email and via phone call between the committing the procuring entity and the IT service provider creating the COVID tracing app. The app goes live, starts collecting data of around 4,000 users. And after a while, the local supervisory authority issued fine for both the public sector entity and the IT service provider for a number of violations of GDPR. What happened on the back of that is that the procuring public sector entity claimed to bear no liability for the data processing carried out by the app because they were actually not the controller of such data processing. Because there never was a contract between the two entities for the purchase of the app. Well, the ECJ did not agree with that reasoning. So they said that in order to ascertain whether there is a position of controllership for a processing carried out by a separate entity, a processor, is not necessary to have an agreement in place. The definition of controller is very broad, given by Article 4.7. Anytime you, with your action, participate or contribute to determining the purposes and means of a processing activity, then you assume the quality of a data controller, which then is there, despite the fact that you may have not carried out the processing activity yourself. You may have not given a green light to the app to go live, and you may not formalize your position with a processor through an agreement. What the European Court of Justice said that in this particular case, the public sector body could have basically got away from the position of controllership only if they had expressly objected to the making available of the app on the relevant apps store. And when it comes to the liability of a controller, the ECJ reminds us that controllers are always liable for the processing activities carried out by processors on the behalf of the controller. That is no longer true only in the moment when processors start going above and beyond the instruction received, because in that moment they assume the quality of a controller themselves. So what are the practical consequences of this? Pay attention to your instructions. That is the first recommendation. Whether you're a controller or a processor, you want to make sure to give very clear instructions to whoever you have engaged in order to not be on the hook for certain processing activities carried out. At the same time, if you're a processor, you want to have very clear instructions to make sure you're not, becoming a controller yourself. Moving on to the last case, we have again a case of liability for a controller. In this case, for the wrongful action of its personnel. We have a real estate agency, DW, that in Germany was fined by supervisory, received an administrative fine from a supervisory authority for a breach of rules around data retention. DW contested the administrative fine, saying that under German law, an administrative infringement can be brought only against a natural person. And only limited circumstances, an administrative infringement can be brought against a legal person for action of a natural person, only after having ascertained the identity of such a natural person and that that person acted as a representative of the legal person. For example, that person is part of the top management of the company. Well, again, the ECJ was not of that opinion, and they said that a legal entity can be liable for any action of any employee, regardless of the position within the organization, as long as they were acting, in their performing their duties, performing their job, and therefore representing the company. Something else that the European Court of Justice added is that there is no such thing as a strict liability regime for controllers. In order to issue an administrative fine, it is always necessary to prove wrongful doing on the side of the organization, wrongful doing in the terms of intent or negligence by the controller. What are the practical consequences? Again, if your organization is liable for the action of anyone within the company, training. So make sure that your people know what they're doing, why they're doing it, and what they're not supposed to be doing. And again, the good news coming out of this is, again, that now SA, in addition to the infringement, before issuing an administrative fine, will have to take into account intent and negligence, which may slow down significantly their activity. So I hope to have covered enough these cases, but I hope you have enough time for your questions now.
That's great. Thanks very much, Marco, and thank you to Michael. So yes, a lot to take away there. As you'll see, we said it was a bonanza, we said it was a bumper year, and absolutely it was. Kind of summing that up, we worked out it looks very hard to use contractual necessity or legitimate interest for targeted advertising. Might, if things go south, even turn out hard to use consent for targeted advertising, in which case, what does that mean for the future of the advertising industry? When it comes to handling DSARs, always a very difficult thing to do. We know they're purpose blind. We know you have to disclose actual recipients. You have to disclose faithful and intelligible reproduction of the data, which might mean documents if necessary to help the individual understand how their data is being used. And when we look at liability and compensation, it's a mixed bag. You have a mixture of, on the one hand, finding out that the GDPR is not a strict liability statute. We know that fines will only be imposed if there was intent or negligence on the part of the controller or processor that was in breach. So, on the one hand, making regulatory investigations that little bit harder to impose a fine. On the other hand, there's no de minimis threshold for harm, and we know that even the fear of misuse of data could amount to a non-material harm. So, a lot of really significant decisions coming out of last year. Now, we have just a minute or so before we wrap up. I could see some questions coming in as we were talking, and I did my best to respond to the ones I could. There was one question here from Gabriella about if you are a European company doing business in other countries, say Philippines, Australia, China, basically which laws are you subject to? Is it Europe? Is it the countries there? The short answer to that, I'm afraid, is it really depends on the law. if you're based in Europe, you're absolutely going to be subject to European data protection law. But if you're collecting data from individuals in any other country, it's really going to depend on what those countries say. They may well say you have to have an office here, or they may say collection or targeting of any individuals in our jurisdiction triggers our law, in which case ultimately you can find you're subject to multiple laws. It's a classic kind of conflict of law situation that we find. And then one question from you, Lynn, as well, about how a controller assesses whether the security measures, the technical and organizational measures of any processor or sub-processor it appoints, whether they are adequate. You know, is it a matter of looking to something like a SOC report to see that they've got sufficient measures in place? I think there's a couple of things here. Firstly, it will depend on what is appropriate to the circumstance. But what regulators will probably say to you is that it really depends on the sophistication of the controller and the processor. The more sophisticated the controller is, the more due diligence they will expect you to do. You know, if you've got an InfoSec team who are very experienced, they will expect you to ask questions. They will expect you to look at audit reports. They may even expect you to conduct your own audits of a vendor's security to determine whether or not it's good enough. Conversely, if you're a mom and pop store signing up Amazon as your hosting provider, you know, I think the regulators would put much more emphasis on Amazon's representations contractually and in things like trust sites as to sort of how their compliance and their security is measured. I'm sorry that takes us just slightly past the hour. We do really appreciate you all joining us today. Please give a big thank you to Marco and Michael for all their excellent effort on today. And if you like this, I hope you tell us. If you didn't like it, I still hope you tell us, because all the feedback's useful. Please do tell everyone. And if you have any questions, our contact details are on the slides. And there is also a final slide with links to all the cases we've been talking about today if you want to go and read them for yourselves. So thank you, everybody, for joining us.